Good morning, Mr. Is it Poston or
Poston.
Poston? Mr. Poston, you're charged with criminal mischief. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. The officer was dispatched to a residence in Harris County, Texas, in response to a family disturbance. The reportee stated the officers that the defendant had engaged in a physical altercation with multiple complainants. The second complainant told the officers that her and the defendant, her stepfather, got into a physical fight and that the defendant pushed her, but did not cause her to fall to the ground or did not cause any pain. The officer then contacted the first complainant, the stepmother of the second complainant, who stated to officers that after the fight, she walked outside the residence to get in her car when the defendant pulled out a pocket knife and stabbed 2 tires on her vehicle, causing at least $200 in damage.
Mr. Poston, I'm going to find that there's probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to have contact with the complaining witness in this case and not to make possession of weapons. Do you understand? If you violate these conditions, I will put you in jail and you will not get any more PR marks. We are going to reset your case to give you time to hire a lawyer. So I'm going to first have you go to Ramona, sign a reset. After that, we'll have you take a seat in the jury box while we get your bond conditions. We'll have you sign it. And after that, you'll be free to go. When you come back, please have a lawyer. Are you Luis Angel Racinos?
Yes, sir.
Mr. Racinos, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On December 20th, 2024, the officer was dispatched to Fondren Road to meet the firefighter call. Upon arrival, the officer was advised by a Houston Fire Department medic that the defendant, who was the driver and sole occupant of the vehicle, was asleep behind the wheel of the vehicle while the vehicle was on and in drive and in the middle of the intersection. Upon contact with the defendant, the officer observed slurred speech, a strong odor of an alcoholic beverage, and swayed balance. The defendant denied drinking. Standard field sobriety tests were conducted. HGN 6 out of 6, walk and turn 7 out of 8, one leg stand 3 out of 4. The DIC was read, but the defendant refused. Blood search warrant was signed and executed. During the reading of the DIC, the defendant wet his pants for a second time.
Mr. Racinos, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. You're going to be randomly tested. If I find that you're consuming alcohol or illegal drugs, you will go to jail.
Eligible license and no priors.
Got it. If you don't have liability insurance in your name, you're not allowed to drive any vehicle. Do you understand? And that is also a condition of your bond. We're going to give you time to hire a lawyer. So I'll have you sign a reset with Ramona. After that, you'll get with Francis for your bond conditions, and then you'll be free to go. Don't pick up any new cases. Do you understand?
Yes, sir.
Okay. Come on. Saquital.
Sakital.
Saquital?
Sakital.
Say it again.
Sakital.
Okay, Mr. Saquital, you are charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. All right.
On December 21st, 2024, officers were dispatched to a firefighter call for a person down at approximately 1:24 a.m. Houston firefighter advised the officer that he observed the defendant to be asleep behind the wheel of his vehicle, despite attempts to wake the defendant with their horn. When the officer arrived on scene, he observed the defendant inside his vehicle while the vehicle was on and in park at the 4300 block of Bylock Road, and the defendant admitted to drinking about 8 drinks and stated he had just left a sports bar. The officer observed the defendant to have glassy eyes, poor balance, and an odor of an alcoholic beverage. Standard field sobriety tests were conducted. HGN 6 out of 6, walk and turn 4 out of 8, one leg stand 2 out of 4. While inventory of the vehicle, the officer located one open 12-ounce Coors Light can in the center cup holder, which was 1/4 full and cold.
Drinking while driving?
Yes, Judge. And the DIC was read, and the defendant consented to breath. The results were .087 and .08.
Mr. Saquital, I'm going to find that there's probable cause to go forward with your case. I'm now taking away your privilege to drive. You are not allowed to drive whatever for any reason. Do you understand?
Yes, sir.
You will be signing an affidavit with me today, promising me you're not going to drive, and I don't care what is going on in your life. If I find that you drive, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. I don't care what your reason is. There's no justification you can give for getting in a car and driving. Do you understand?
Yes, sir.
This is a court order. This is an affidavit and promise you're making to me now that you're not going to drive. Heed this warning. I'm also ordering you not to consume alcohol or illegal drugs, and I'm going to randomly test you. If I find that you're using, likewise, you will go to jail. No more PR bonds. We are going to reset your case to give you time to hire a lawyer, so I'll have you swear to this. We'll get you to Ramona with your reset, and then Francis for your bond conditions.
It's bonded out.
Okay.
And he's already received his bond conditions for the magistrate, and I reviewed them pretty well.
I don't know. I don't know anything about the case, so we'll go through it. And
I know.
good morning, Mr. Rada.
Good morning, sir.
Sir, you're charged with terroristic threat. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge.
Please.
On May 14, 2024, the officer responded to a resident in Harris County, Texas, in reference to a terroristic threat. The officer made contact with the complainant, who stated the defendant, the wife's uncle, threatened to return to the residence with a shotgun to shoot him, and that he would shove the complainant's pistol up the complainant's ass, and that he would return with a cartel so they could take care of it. The complainant stated he believed the threats to be imminent and he feared for his life.
How did you get appointed so early?
He made a request for appointing counsel when he was in jail in Montgomery County.
Okay, so he was,
And y'all appointed me, and then he got transferred here and
got it.
received his bond conditions and general order bond last week.
All right, Mr. Rod, I'm going to find that there's probable cause to go forward with the case. I'm putting 2 conditions on your bond now. Not to be in possession of any weapons and not to have contact with the complaining witness in this case.
Yes, sir.
How long did you spend in jail, sir?
I was there the 14th all the way up to the time they transferred me here, and I believe I was released on the 20th.
How pleasant was your stay in custody?
It was not pleasant at all, Your Honor.
Then all I'm asking you to do are 2 things, and as long as you can do that, you and I will be best friends. Otherwise, it's not going to go well. I don't want to have to put you in, so just, that's all,
I
okay?
understand, Your Honor.
Got a great lawyer, Carl. He'll take care of you. Just make sure you stay in contact with him and all will go well.
Yes, sir.
If he tells me he can't get a hold of you because you're playing games, you're off the radar, I will issue a warrant for your arrest, okay? Just stay in contact, follow the conditions, and that's it,
Yes, sir.
okay? All right,
Thank you, Your Honor.
we need him to sign conditions here, and then after that, he's free to go,
Okay.
okay? All right. Are you Taisha Willis?
Yes, sir.
Ms. Willis, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. The officer was dispatched to a residence in Harris County, Texas, in regard to an assault. The complainant, the defendant's daughter, told the officers that her and the defendant got into an argument, and the defendant struck the complainant in the face with her hand, causing pain. The complainant and the defendant then began fighting. Multiple witnesses told the officers that the defendant was the aggressor and hit the complainant first.
Ms. Willis, I'm going to find that there's probable cause to go forward with the case. What's the relation?
It's the defendant's daughter, Your Honor.
Do we know whether the daughter wants to have contact?
Your Honor, we have not had a chance to reach out to the complainant yet.
I don't know if she wants to have contact with you, so until I do, I'm barring you from having contact. You understand? There is a protective order that has been entered in this case. I would get to know it because if you violate the protective order, the state can file additional charges of violation of protective order against you, and it's one of the worst cases you can pick up in misdemeanor court.
Can I question something? You said that it was a residence, that we were in a residence.
Let's not talk about the case now. Now's not the time. I've got DAs here. Anything you say, they're going to use it against you, even if you
It was
think
at Walmart, not a residence.
doesn't matter. Just don't. So, what do you do for a living, man?
Drive school buses part-time.
Okay. What kind of income do you have?
Part-time, it's like probably less than 18 a month.
Okay. Do you have the ability to hire a lawyer?
No,
You want to apply for an appointed lawyer?
that'd be fine.
Okay. I have it on file. So for now, ma'am, I'm going to have you go to Ramona, sign a reset. We'll have you take a seat in the jury box. I'm going to have you sign bond conditions. You're not to have contact with her and no weapons. And then I'll try to find you a lawyer. Okay?
Okay.
Please.
Flip it the mullet.
Jefferson, Your Honor.
Good morning, Mr. Jefferson. Did you get the cause number?
Yes, Judge.
I didn't. Mr. Jefferson, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On December 22nd, 2024, at approximately 3:30 a.m., the officers were dispatched to the 800 block on Louisiana Street in regard to a motor vehicle parked on the Metro light rail tracks. Upon arrival, the officer observed the defendant's vehicle on the tracks with the defendant asleep behind the wheel of the vehicle.
On the tracks?
Yes, Judge.
Ugh.
The vehicle was turned on and in the park position. Upon contact with the defendant, the officer observed slurred speech, glossy eyes, and an odor of an alcoholic beverage. Standard field sobriety tests were administered, 0 out of 4 on the one-leg stand, 0 out of 8 on the walk and turn. The defendant did not finish the test, and HGN was 6 out of 6. The DIC was read, and the defendant consented to breath. The results were .091 and .09.
He's on bond for an aggravated robbery.
Yes, Judge, that is correct. Out of the 174.
Is that case set for trial now?
Yes, Judge.
All right, can you tell me if he has any prior DWIs, please? And
There's no
if
prior
he has a license?
And his license is eligible.
Mr. Jefferson, I'm now placing a restriction on you. I'm giving you a curfew of 9 p.m. to 6 a.m. And I'm going to put an ankle monitor on you so I know where you are at all times. You're on bond for a very serious case. Now you've picked up a new case. It's very possible they revoke your bond on the felony case. Do you understand? I don't want you out in the middle of the night. If I find that you violate these conditions, I'm going to put you in custody. I'm going to protect my county at all cost. Do you understand? If I find that you're consuming alcohol or illegal drugs, likewise, your bond will be revoked. You will go into custody. And I'm telling you now, if I find that you're a public danger, I'm going to make it sky high. You missed court yesterday. So I don't want you to say anything. You have the right to remain silent. Exercise that right. The only thing I'm telling you now is I will give you a pass because you missed yesterday. If you ever miss court again, this is not going to happen. Do you understand? I'm going to reinstate the bond now. Francis, do you need the cause number for this case?
I have it.
You have it? Okay. No alcohol, no drugs, no weapons. And he now has a GPS monitor with a curfew of 9 p.m. to 6 a.m. You must charge this ankle monitor on a daily basis for at least an hour. If the battery goes dead, so does the bond. Do you understand?
Sure.
You can waive all the fees as well. Right. I'd like him to get it today as well. Francis, please. All right, Mr. Jefferson, what we're gonna have you do is I'm gonna have you go to Ramona, sign a reset, and then you're gonna get with Francis for your bond conditions. You're already in enough hot water as it is. All you're doing is you're adding fuel to the fire, man. Really, don't say anything. I'm just telling you how to behave in this life. There's certain ways to act, certain ways not to. Do you understand? Come on. Perechu, come up. Mr. Perechu, you were charged with driving while intoxicated back in 2022. You took off. We issued a warrant for your arrest. The only reason that we have you back now is because you picked up another DWI. So you have 2 open DWIs. Your bond on the first one is set at $5,000. We're going to do probable cause on your second case. You have the right to remain silent. Anything you say can or will be used against you, sir.
On December 25th, 2024, the officer on view to DWI investigation at 7600 Harwin in Harris County, Texas. The officer heard a loud bang and observed the defendant's motor vehicle driving on the median heading eastbound. A traffic stop was initiated. The officer observed the defendant immediately opened the door and stepped out of the driver's side. The officer observed a strong odor of an alcoholic beverage, glossy red eyes, slurred speech, and standard field sobriety tests were conducted. HGN were 6 out of 6 clues, and the defendant stated he no longer wanted to continue standard field sobriety test and to just do breathalyzer in jail. The defendant read the DIC and consented to breath. The defendant later said that he was on his way home from his friends and was turning left on Harwin and got on top of the median due to being drunk. The defendant stated he consumed 4 Heineken 16-ounce beers, and the results of the breath test were 0.205 and 0.212.
Oof. Mr. Perechu, I'm going to find that there's probable cause to go forward with the case.
Judge, if I could argue against that real fast.
Sure.
My understanding is that the reason for the stop was a loud bang, that it didn't be articulated into any kind of reason for a traffic stop.
Well,
Loud
He's
bang.
driving on the median.
Ricardo, the officer further
Bang is
observed
what
him
drew his
driving
attention,
on
and then
the
he's driving on him.
Ah,
Yes, Ricardo.
okay, I didn't hear that.
No problem.
Okay. Yeah, that's pretty.
I find that you are a complete and utter flight risk by clear and convincing evidence. I find that you are a danger to my community. You were given a PR bond on this case, and I am now going to revoke that PR bond, and I'm going to set your bond at $10,000 and 2 on the new case. And I'm also going to mirror that on the first case. You now have an immigration detainer and are I guess he's stuck like Chuck now. You got the immigration detainer, you know? If for some reason you do get out, I am barring you from driving at all, and I'm giving you home confinement with a GPS monitor on one ankle and a scram ankle monitor on your other. Do you understand? Mr. Perechu, when you come to court, good things happen. And when you take off like this, nothing good happens. And now you will see this. All right, so I guess we'll just do whatever you want as far as a reset with Mr. Perechu.
His other cases on the second,
He revoked the bond.
the one you stated on. Okay.
If you want to leave it on there, if you want to do different dates, whatever you want, I'm happy to do it.
Just let me know in a few minutes.
Okay, sounds good. Thank you, Judge.
Judge, Mr. Franklin is here. I'm still with